Hi, I'm Jeff Marsacci, the Plain English Attorney, and you're at the #1 place to get simple answers to complex questions. We cover topics for attorneys, financial advisors, and the general public around estate and Medicaid planning, as well as some best practices for professionals. Our mission is to dispel myths, provide you some peace of mind, and hopefully have some fun along the way.
Hi, Jeff Marsacci, and today we're going to talk about and group 6 documents into this one video because most of the time our clients do understand this. It's just a quick overview. If there are specific questions, please go ahead and look up our other stuff or talk about it in the document review meeting if that's what we're going through. The first is the Durable General Power of Attorney. This is a critical document when you're talking about care assistance planning not because of the property aspects, but the ability to gift and move money around to qualify for Medicaid as part of this whole deal. That's important, and somebody needs to be empowered to sign tax returns. Somebody needs to be empowered to step into your shoes financially and handle things for you. And that becomes a critical document in trying to get things moved around in order to qualify for Medicaid when the time comes, when you become incapacitated. So that's, again, a critical document. There's also the healthcare power of attorney. So who gets to make healthcare decisions for you if you're not able to? Most people understand that, but the way we draft these documents, just to give you a little bit of insight on that, if you're going to trust a person enough to put your healthcare into their hands, don't start trying to limit, oh, they can't do this, they can't do that, I don't want them to do this, they shouldn't do this, and then, oh gosh, they could never do that. That then becomes more of an issue of, do you really trust that person to be your healthcare agent? And the far better solution is to talk to them about those things and what you would prefer. Right. So now we also have the living will. That is the one decision at the end of life where the doctors are saying they're terminal and incurable, there's nothing else we can do, or they're in a persistent vegetative state. Okay, we can keep the body going on the machines and the nutrition and the hydration. Do you want us to do that, or do you want us to just let them go? This document says what you want. This is not really as much for your benefit as it is for your healthcare agent, because they don't have to feel like they are making the decision to, quote, kill you. I've heard my clients' kids say that. I feel like I killed my mom because I told the doctor to pull the plug. Even though she told me that's what she wanted, I still feel guilty. The living will is your instructions, writing, signed, witnessed, notarized. This is what I want, and it just makes things smoother for the family. Right, now we also have the nomination of conservator document. This just lays out who are guardians for you if you ever get to the point where you need guardians appointed by a court. Now, all of the documents and everything else that we put together, that should be enough, but if there's ever a challenge, we just have your financial people, your trustee, power of attorney, that same exact list. That's in there to be your guardian of the estate. And the people you've chosen to make healthcare decisions for you, those are your guardians of the person. So it all lines up in a coordinated plan. Now, there is one more document. It's a, quote, final health decision, but it's after you're already gone. If you want to be an organ donor, for what purposes do you want organ donation? Because technically, if you want to be an organ donor, your body could be donated to a medical school, and you could end up being a cadaver for a whole year for those first-year medical students. Maybe you want to do that. A lot of my clients don't. When they're thinking, oh, I want to be an organ donor, it's, oh, if somebody's sick, take the organs or tissues and help someone who's sick right now. Not the research, not teaching medicine or any of that stuff. All right, well, this form will differentiate that. And if you don't want to be an organ donor, all right, we're also going to use the form, but we're going to cross everything out and write no organ donation. So that's still your wishes. So that's 5 of the documents somewhat related to healthcare for 4 of them. And the last one is you do need a will. In this whole toolbox setup, we've mentioned all of the action for your estate is happening in that family irrevocable trust. So who's the beneficiary of your will? The family irrevocable trust. So if there's anything that for some reason ends up in probate, okay, a vehicle, you had a checking account with $200 in it, okay, fine. That has to go through probate, but then the beneficiary is the family irrevocable trust. So it coordinates everything together. So those are the 6 big documents that we call the ancillary documents: durable general power of attorney, healthcare power of attorney, living will, nomination of conservator, that organ donations form, and the pour-over will, last will and testament. So we hope you found all of this information useful, and it can help you understand the different documents that are inside the toolbox. And so when we sit down and we meet for the document review meeting, we can get more into the specifics of the documents as opposed to, wait a minute, what does this document do and why is it different from this one? We can focus in our discussion and talk about the exact language. So we hope that was helpful, and we look forward to seeing you at your document review meeting.
We hope you found that information useful and easy to understand. To keep getting this great information, please like, subscribe, and turn on notifications. To get even more information more quickly, follow the links below to some of our free, no obligation programs.